Hi, Brian. It's Maddie. How are you?
I'm well. Nice to meet you.
Nice to meet you. Let me make you the host quick.
Oh.
Let's see. And were you comfortable sharing your screen, sharing the PowerPoint?
Yep, I know how to do that.
You can do that? Okay, perfect. All right, let's see. Perfect. You are the host. All right. So we had 6 total register. So yeah, whenever you want to start, maybe wait a few minutes and then you can get going.
Maddie, I can barely hear you.
Oh, okay. Can you hear me better now?
No, I mean, I can hear you, but not well.
Okay. How about now? No. Okay. Shoot. All right. Well, I'm not going to be on the call, so I'm gonna head out. But if you have any questions, just shoot me an email.
Okay. Do we have everyone? I mean, we're 2 or 3 minutes ahead of the time, so I guess I'll wait until.
Yeah. Yep. I'd wait till maybe 5 minutes after.
Oh, okay. I'll start.
Right.
I'll start a few minutes after 12.
Okay. Perfect.
Thanks.
Yep.
Filming and acting, and dude, I want to watch a car show about building cars. I want to see and Ken, I mean, he just built his own Corvette now, carbon fiber body Corvettes.
That
53.
Ian Russell.
Oh, I like Ian.
Yeah.
That's the ball guy.
Yep.
Yeah, I like his show. But that's a little.
For those of you just jumping on, I'm Brian Imchek. I'm the presenter, and I'm going to start in about 2 or 3 minutes. Give stragglers a chance to log in.
He does.
But that
Hey, Amanda. It was fun seeing you last night.
Thank you. I appreciate that.
Some.
Okay, folks, let's get started. If you can't hear me or have issues seeing me or have any other technical issues, please let me know. Or same thing if you can't see my slideshow, which should be hopefully visible to all of you at this point. My name is Brian Nimchek. I'm an attorney with the law firm of Hellmuth & Johnson. I practiced law for about 15 years, and for most of that time, I've dealt with all types of issues involving employees, employers, and often independent contractors. And the purpose of my presentation, or the topic I'm going to address today, is the difference between employees and independent contractors in your industry, the construction industry. And obviously, it's a major issue for many in your industry. And it's something that the government looks closely at compared to other industries because of the prevalence of subcontractors being used to actually do construction tasks as opposed to in-house employees. So there is some fairly clear guidance from the legislature on this issue. We'll go over that. We'll discuss how best to avoid any problems with any government agency or individual who makes claims, and we'll talk about why it's important and how if things go wrong, it can really hurt your business. At any point, please pipe in and ask any questions you may have, and I'll be happy to address those as we go along. I'll also ask for questions at the end. Okay. To begin with, it's certainly common in your industry to call the people who work with you independent contractors or subcontractors or a similar term, and to treat them as such for tax purposes. It's easy to see why, as both parties can save money on payroll taxes, workers' compensation, and various other types of obligations and duties that employers would owe to employees and that employees would owe to employers don't exist. Because at least theoretically, there are just two businesses entering into a contract as opposed to an employee working for an employer. However, the rule of thumb, and something you should keep in mind, is that if someone works for you, they are an employee, unless they meet a very specific set of legal requirements, which we'll go over in this presentation. The real key, the touchstone of this analysis, and it can get complicated, messy with lots of factors and elements and issues like that, but it all really comes back to the idea that employees are people who can be controlled by the business they work for in a systematic and comprehensive way. And independent contractors are independent. They can't be controlled in the same way. You can't either theoretically have that power or actually have that power to control them as you would an employee. So that's what all of the analysis really comes back to, the extent to which we're talking about an employee who can be controlled or a truly separate and independent business which can't. And all the kind of tests that have been come up with by the legislature or courts are try to get at that issue. Now, just speaking again generally, a contractor who hires a subcontractor or an independent contractor can still exercise extremely broad control over the jobs. Can say, well, you're going to put a roof on this house and it's going to have the following color shingles and it has to be done by 2 weeks from now or something like that. That's fine. But you cross a line if you start telling them exactly how to do it and overseeing their work in a more systematic way. And we'll get into the details there, but we're talking about very, very broad 35,000-foot view of what the difference is right now. Kind of the classic example is the plumber you hired to come fix a leaky pipe in your house. You kind of control the plumber, I guess, by pointing him or her to a leaky pipe and saying, fix it. But that's not the sort of control that would get you into trouble as far as the employee independent contractor distinction. Because hopefully the plumber has their own tools and does everything in a manner that they see fit based on the training that they have that you've hired them to do. So we'll get into some details. First, it's important to understand that there is a general test under Minnesota law that applies to most industries and applies to your industry to the extent you're working with people who aren't actually construction contractors or subcontractors. If you're, for instance, trying to treat your salespeople as independent contractors, or you have some administrative staff that are being treated as independent contractors, this is the test that would apply. We'll see later that there's a more detailed test for the people actually doing work on the project, but you should be aware of this other test, which dates back more than a century and was created by courts, and deals in a very general sense with the idea that the contractor should be independent and that the control over them should be limited. But I'm not going to spend any more time on this test. It's not really the issue that animates the questions and concerns I know that most people in your industry have. So again, the law gives additional direction to subcontractors in the construction industry. I think the law started, or this law came into existence in 2007 in response to concerns that started to arise before the Great Recession and became extremely important to state legislators during the recession and the housing downturn, when many quote unquote subcontractors in the construction industry started getting laid off or stopped having enough work, and they began applying for unemployment, or other things started coming up where they started claiming there were employees, perhaps out of necessity. And this really became an issue in a time when the unemployment trust fund was being depleted, and there was concern that it wasn't being filled up as it should because too many people were being misclassified as contractors as opposed to employees. So one of the legislative responses was to, and we'll talk about some other ones, but one of the legislative responses from that era was to create a set of elements that any supposed subcontractor in the state of Minnesota, construction subcontractor, would have to satisfy in order to be truly considered a independent contractor under the law. And there's a list of them on this slide and the next one. We're going to go over each of them in detail, so I'm not just going to read them off, but you can see them. And again, they get at, in a way that's meant to be specific to your industry. These elements are meant to get at the idea that you should be having two separate and independent businesses without one controlling the other, and not just kind of a person, or I guess small company that's just attached inexorably to a larger contractor. So we'll get at each one of these elements, and I'll talk about some of the things you need to do to comply with them, and hints and tips of how to do that kind of in real life as opposed to just in this theoretical exercise. So again, if you do need, the IRS has a different test, and we're not going to get into that one because that generally doesn't affect you. It's the Minnesota test we're concerned about. So the first element, and again, these aren't factors. It's not like the court or an administrative agency that kind of weighs these and puts them in a hopper and then decides how many, if you've satisfied more than half of the factors, then you win. These are elements. You have to meet each and every one of them in order for someone to be a contractor. If you miss out on even one, then you've got yourself an employee. So the first one is the question of, does the supposed independent contractor maintain a separate business with their own office, equipment, other facilities? Where I see this and where this comes up in your industry is the supposed subcontractor who basically conducts all of their office business out of a general contractor's office. They use office space, they use computers, they use office staff, they use copy machines, they use your paper, they use your pencils, they use your your paper clips or whatever else. All of that stuff is, they don't have a home office or a separate office space of any sort. They just kind of use your equipment, which is perfectly fine and frankly expected if they're employees. But if they're really a separate and independent business, any administrative agency or court examining this would look closely at this, who supplies the kind of ancillary materials that allow a business to be, that the the subcontractor's business to be run. It could be a home office with a laptop. As long as it exists and the contractor can show it exists, this factor or this element should be satisfied. If they can't, if it's really just, well, I use the office and the back office, I guess, facilities and services of the general contractor, then that's a problem. Now, I'm often asked, well, sometimes they, once in a while they make a copy in my office when they happen to be there. I mean, that's fine. It's what will really get you into trouble with this, and several of the other elements are kind of systematic, major, I guess, violations of the element, or major efforts by the both contractor and subcontractor to I guess treat one another as employer and employee, or as not being separate and independent entities, as opposed to the once in a while thing. So once in a while they use your facilities, fine. If it becomes a systematic thing, that's where you run into trouble. But the first one is looking at back office stuff and equipment that's used for kind of operation of the business. And anyone looking at that is going to want to see a completely separate operation. It can be a simple operation, but it has to be separate. Next, do they use their own tools, equipment, supplies, etc., to actually do the work? Before we were talking about the kind of back office stuff. Now it's the actual truck, the hammers, the nails, whatever else they need to do the construction work that they're providing. Is that supplied by them or supplied by you? It should, for the most part, be supplied by them. Now, there's an important clarification to that was provided by the Court of Appeals about 10 years ago. And the story is interesting and something that I think helps people understand what they're getting at here. It was a tile installer who was specifically in a written contract hired as a installer of tile. And this person was treated as a subcontractor. Things went haywire with that relationship, and it ended, and that subcontractor then applied for unemployment, saying, hey, I was really an employee. And it turned out in the unemployment process, it came out that the actual tiles, the tiles themselves that were being installed by this guy, were supplied by the general contractor, as of course you would expect in the normal course of business. And the unemployment judge took a look at that and said, well, that's sounds like a supply to me. And if this person was, their supplies were covered by or provided by the general contractor, that means this element isn't satisfied. That means this person is an employee. Happily, that decision was appealed to the Court of Appeals, which said, hey, wait a minute. This person was hired to install and not to, you don't have to, it's not dispositive or it's not important that the actual material that they were installing came from the general contractor. That would be expected. But the tools that he uses to install and the supplies that he needs to install those tiles are the things that we need to look at, not the actual building material, which both is a matter of kind of course in these sorts of relationships, as you know, would be generally provided by the general contractor, or I guess the homeowner or business owner themselves, and not by the an installer subcontractor. But that decision provided some helpful guidance and clarification on that issue, that if you hire an installer and you provide the building materials that are needed to be installed by the person being treated as a subcontractor, that's perfectly fine. You don't violate this element. Now, it was important in that case that this person was hired in writing as an installer. So to the extent you don't have written agreements that say that, to the extent you're hiring an installer, you should make that clear, that the scope of your services are to install the things we provide. And if you have some other arrangement where they're providing the materials that they're installing, fine. But it should say that and make it clear, because it was really helpful to the general contractor's case in this situation to have that agreement specifically talk about installing. So tools, equipment, supplies, generally speaking, those need to be provided by the subcontractor. Now, again, if once in a while they use one of your ladders, it's not going to probably send the FBI raiding your business. But in the normal course, in the general, the general operation of the business, they have to use their own supplies, tools, and equipment to do the job. Separate, they want to see that the independent contractor, subcontractor has a separate tax ID number. If they're a business, it should be something other than their individual social security number. If they happen to be a sole proprietor, then that's fine. It can be a social security number. But a separate tax ID number is important. They should form a business entity. That's certainly advisable. And to the extent they do form a business entity, they should get a tax ID number. But if they, for whatever reason, don't, it's problematic under this test. Whoa, sorry. So the next one, I don't understand why they combined really two things into one element, but this is what the statute says, so we'll roll with it. So there's basically two issues here. The first is, do the parties, both the contractor and the subcontractor, have signed contracts for specific amounts of money? And a second, do they control the means of performing the work under the contract? So, if there's one guiding theme of this, it's that there is a contract. Ideally in writing, although it wouldn't necessarily have to be, but it's certainly helpful to have a nice written contract that says exactly what the subcontractor will be paid for that job, an amount that hopefully was arrived at after some kind of legitimate negotiation through a bid process or whatever else. And that the contract says that the means of performing the work under that contract are the subcontractor's responsibility. So the written contract should be developed, hopefully in consultation with a lawyer or someone else experienced in the area, should be developed to really make clear that this person is not an employee, they're not controlled by you, that they're responsible for all of their own business expenses, and that they're paid according to a negotiated price and not, as we'll see later, some kind of hourly rate for however long they spend. You see a contract like that, either ideally in writing, but it could be verbal if necessary. You'll meet this test. Next, they look at whether the subcontractor or the person or company that's claimed to be a subcontractor incurs the main expenses relating to their work. Here we're getting at situations where a general contractor perhaps directly pays for a truck or mileage or training or insurance or something else like that, that they would normally do for an employee, or that would be perfectly standard operating procedure for an employee, but which is problematic if you want to treat that person or entity as a contractor. Those main expenses of a business like a subcontracting business are meant to be rolled into whatever the job cost is, and that job cost, out of that job cost, the total job cost, the subcontractor themselves has to pay those expenses. If they have mileage expenses or training expenses or whatever else, they've got to build that into the price being charged to the general contractor. If they're either being, just direct, if those expenses are either being just directly paid by the general contractor, or if they're like reimbursed on a dollar for dollar basis, you're kind of submitting your receipts as a subcontractor to the general contractor, that's bad. That's a problem. It has to be rolled into the broader job price. It's certainly, you internally within the subcontractor's office, as you draft up your bid and calculate what you're going to charge, you should take those expenses into account. That's just good business, and they can be built into the price being charged to the general contractor. That's what you should do. But if you are being reimbursed dollar for dollar, or the general contractor is paying those expenses directly, the law will deem those to be not really two separate and independent businesses, but instead a de facto employee. This is the next one is, does the subcontractor have continuing or recurring business liabilities? I think this is real similar to the last one. the last one talked about main expenses. I guess this one's talking about things like ongoing costs for rent or insurance or, licensure expenses, or like the expenses of setting up a business, or maybe they pay their lawyer to draft a contract or something. Those are the sorts of things, that kind of recurring ongoing expenses, insurance, whatever else that a normal, separate, truly independent business would have to pay on a weekly, monthly, yearly basis. Those need to be expenses of the subcontract and not paid directly by the general contractor or reimbursed dollar for dollar in some way. Those expenses need to be, incurred and paid on a regular basis by the subcontractor in order to demonstrate that they really are a truly independent, separate, legitimate business and not just an offshoot of another business. Next, we look at whether the subcontractor is liable for a failure to complete the work properly. In other words, could they be sued for doing a bad job? Generally speaking, if a employee screws up, just does a bad job, is negligent in the construction work that they perform on a home or a business, that employee would generally not be personally liable. The party that would be liable would be their employer, the contractor, whoever it was who was actually hired to do the work. Now they assigned an employee to do that, and maybe they fire that employee for doing a bad job, but generally no one could or would sue that employee for doing a bad job, unless, weird fact circumstances where they, like, I don't know, intentionally destroy something or punch the customer or something like that. Then then in that kind of intentional tort realm, the employee would be personally liable. But if you've got an employee, generally them screwing up will only result in them getting fired, not directly sued in their personal capacity. If you've got a true independent contractor or independent subcontractor, however, that liability flows differently. The general contractor is not automatically liable for the screw-ups of the subcontractor. The subcontractor is responsible for their own negligence, and perhaps, hopefully, they carry insurance to cover that, or are otherwise responsible for paying for a problem or fixing a problem themselves. If that's not the case, if kind of at least if on paper or de facto, the general contractor is simply responsible for all screw-ups of the people who are supposedly subcontractors and truly independent businesses, then you're not going to meet this element. Now, certainly that liability can be shifted or massaged through contracts, and if that's done in a business type way, that's fine. But what they're looking at here is the subcontractor's non-liability for those sorts of things, as would happen if they were employees. If that's the case, this element won't be met. And real important, we can't pay subcontractors on an hourly basis. There has to be some other way, usually it's per job. There's a bid or other type of agreement that two truly independent businesses come to relating to how much is going to be charged for the job. And you enter into an agreement or perhaps an addendum to a master agreement that says, I'm going to complete job X by December 31st, and the cost is going to be $25,000 or whatever. And subject to change orders, if something changes, that'll be the cost, and it'll be paid by January 31st or something. And the parties agree to that. You sign a little piece of paper saying it, and you're done. You've got a nice contract that is entirely consistent with what the government expects of truly independent subcontractors. Where you run into problems is, well, I'll do this work and bill you $50 an hour for me and $40 an hour for the laborers. And however long it takes, you'll cut me a check for that. I'll send you an invoice for the hours, of whatever hours I spend, and you'll then pay me. That's real problematic. I can think of certain scenarios where perhaps you could defend paying a subcontractor by the hour. They're very few, and they would probably involve emergency type situations, restoration work of a flooded basement that really there's no time, no chance for anyone to submit a bid or get together and have a meeting of the minds on the total scope of the work and the costs, and you just need to get in there immediately and do immediate work. At least, and for a day or two until such time as such an estimate and such a bid might be possible. Maybe you could get away with doing some kind of hourly rate, but short of that, if there's any chance at all for the parties to get together and reach an agreement on the job. Now, it could be subject to change orders. Maybe you don't know everything yet. You've got a roof that you're not sure if there's any water damage underneath it until you take off the roof. So you have an agreement as to the cost of removing and replacing the roof, subject to change orders based on the work that may or may not be done or discovered once you take the roof off. Perfectly fine. But to enter into a however long it takes and however many hours it takes, I'll be paid an hourly rate no matter what. That's an employee arrangement, not a subcontractor arrangement. And the law really, really cracks down on relationships based on supposed independent contractor relationships based on hourly rates. The last few of them are real similar as well. They look to whether the last few elements, that is, the government will look at whether the subcontractor has any risk. In other words, can they lose money if they don't do a good job or if they take too long to finish the job, longer than they had anticipated, budgeted for, or whatever. An employee doesn't take those sorts of risks. They get paid for the work they do, no matter what. And if they do a bad job or take too long, they get fired or disciplined or transferred or something, or yelled at. They don't not get paid. If a subcontractor does a bad job, then they could lose money. If they would only make money if the project took them 40 hours and instead it took them 60 hours, they'll probably lose money. If they estimated that they could get certain equipment for X dollars and it turned out to cost a lot more, maybe they don't make a profit on that job. That's totally normal for a truly independent business. They're not just paid no matter what. They may lose money depending on how good of a job they do and whether their costs are kept in line with what they contracted to be paid. If that's the case, then you meet this element. If it's not, then you've got an employee. Similarly, if they, lose enough money or do a bad enough job on enough projects, can they go out of business? That's, I think, a corollary of the last one. So if they really have risk of losing money, that means they also have risk of going out of business in a way that's just not possible for an employee. Okay, so the reason we have all the special statute and the elements we just discussed are that government agencies, especially starting in the late aughts, were targeting construction contractors for special attention when it came to the misclassification of individuals who were working on mostly homes. So we have this bevy of laws, including another one, the independent contractor exemption certificate law and its progeny. A few years ago, much of this presentation was devoted to this new law, and it had onerous registration requirements and could easily be avoided through the formation of an LLC or a corporation. What it was that many of you may remember it. What it was that if you could go to the government as a subcontractor and present all sorts of evidence and information to a bureaucrat saying, I totally am a subcontractor, and I want you to give me this certificate saying that I am a subcontractor, and you could get one. And that would mean that you are a subcontractor in the construction world. The problem was it was taking a long time. This is a bureaucracy after all. There are a lot of subcontractors, and it's not like you needed one of these to act as a subcontractor in Minnesota. You could also just form an LLC and be exempt from it. So it didn't work very well, and to its credit, the state acknowledged that and scrapped the program after a few years, replacing it with a, at the time, temporary pilot program for subcontractor registration, which we still have to this day. It began as a pilot certificate program back in 2012, and it was fundamentally different from the ICEC program that it preceded, in that there was no bureaucrat that was investigating the bona fides of whether a subcontractor really was a subcontractor. By getting this certificate, it meant nothing other than that you claimed you were a subcontractor and told the government that you held yourself out as one and consider yourself to be one. There's no investigation whatsoever that you actually are one. And hence getting this certificate doesn't mean that you are one. It's not like if you get one and later someone investigates and finds that you really aren't a subcontractor or an independent contractor, you can hold up the certificate and say, hey, but I have one of these. So the registration process is not onerous. You just have to fill out a simple form online, and it's a searchable database of companies that claim to be independent contractors. And but you need one of these certificates, subject to a few exemptions that I won't get into in detail. But most subcontractors in Minnesota in the construction industry need one of these certificates to fill out the simple form in order to really be a subcontractor under Minnesota law. And certainly as a general contractor, your contracts with subcontractors should make the subcontractors agree to carry, maintain, and always keep an accurate and up-to-date registration under this certificate program. And also the general contractor can very easily check to make sure that they are in this searchable database. And notably, subcontractors who operate as business entities have to register. Now, the purpose was to gather information. The state was like, well, we're going to do this and kind of gather information on who's out there and how many people are claiming to be subcontractors. And we're going to use that to create a big old report that we're going to present to the legislature so the legislature could more comprehensively address this problem. And you bet they created a heck of a report. It's online, many, many pages long. And you can read all about the conclusions of the state government on this issue after the pilot program expired, I think in 2014. And the legislature said, thank you, okay, we're going to change the law by making the pilot program permanent. And they have done nothing else to address the situation since, at least at the legislative level. So in any event, it's your government at work, but it's the system we still have. It was intended to be a pilot program, but it's a system we still have. And the key to it, the key thing is that as a general contractor, you should make sure that the subcontractor is registered. You can do that easily, and subcontractors of any stripe who are performing construction work need to be registered. Like I said, it's illegal to hire an independent subcontractor who is not registered. Importantly, we early in the program, we as a firm ran into a situation where the department was asking whether a general contractor's independent contractor salespeople were registered. And we actually worked with the department to say, hey, wait a minute, what are you doing? This only applies to construction subcontractors. And they backed off. They said, oh yeah, you're right. That was a typo or a mistake. So we have that clarification that construction subcontractors, not your salespeople, not your administrative staff, not, I don't know, your lawyer, any other subcontractors you might hire are not subject to this registration review. The Department of Labor's focus is on construction subcontractors. Kind of the last subtopic here is, why does it matter? Why is the government up in arms about this? Why do they target your industry? What is the big deal? Adults or everything want to be independent contractors. What does the government care? Well, taxes. They like to get their taxes. All these different agencies, they want as much in the way of taxes as they can get. And so that's why they're very interested. Both the state and federal governments, they both want to collect taxes, and they want to make sure that the taxes that come in are sufficient to fund the programs that are intended to benefit employees, especially the unemployment program, but there are others. And they want to make sure that employees are protected financially and in terms of the duties that employers have to employees in situations where there legitimately should be an employment relationship. And that's a legitimate concern. It's an interesting question whether that concern has been taken too far, but that's a question for the legislators, not for the lawyers. So the renewed emphasis or the renewed focus from the Great Recession, I don't think has left us yet. We still see a good share of Department of Labor investigations, Department of Revenue investigations or workers' comp audits or things like that that come down the pike addressing problems or supposed employees who are working as independent contractors in the construction industry. So what could happen? You know, like I said, these things come up. You know, what's the worst that could happen if you know, hey, they misclassify someone? Oops. So really bad things. I mean, you don't want to be crosswise with the government. They have, you know, they have free attorneys who do nothing but this, and you know, will be able to wait you out and outspend you no matter how much you want to fight it. So both the IRS and the Department of Revenue can seek to recover unpaid withholdings from both the company and from owners individually and personally. So if you own a construction general contracting company and you were in any way involved in the decision of how to classify a certain individual, you know, as not an employee, and it's later found that that decision was wrong or illegal, the taxing authorities can not only sue the company itself, but they can sue you personally. That LLC or Inc. that you set up to avoid that scenario, yeah, the government makes the rules. They can ignore it if they feel it's necessary in order to actually recover that money. So owners personally liable for failure to withhold because of misclassification. The unemployment department can do the same thing, and they're the worst creditor ever to have. I hope none of you have had or ever will have the unemployment department after you for money, but they have a special power where they can just declare that you owe them money, and without going to court or getting a judgment, they can just start garnishing your bank accounts because they're the government and they've given themselves those special powers. And so it can be difficult, expensive to fight the unemployment department when it decides it wants some money from you, which goes for most government agencies. So the situation can also sometimes give rise to unpaid overtime and minimum wage claims by people who you treated as independent contractors, but who are now conveniently claiming they should have been employees. You know, maybe some of those folks worked more than 40 hours and weren't paid time and a half, 40 hours a week, that is. Maybe some of them feel that they weren't paid minimum wage. Those sorts of claims end up in federal court. And, you know, maybe there's only $200 at stake in terms of the amount of supposedly unpaid wages, but you can be on the hook for their legal fees as well. So it can be bad news all around to get dragged in one of those things, and certainly can happen in misclassification scenarios. Possible criminal prosecution. That happened, I think, about 18 months ago. A general contractor was brought up on criminal charges for kind of intentionally avoiding taxes by very, very blatantly misclassifying a whole bunch of people as subcontractors and trying to manipulate everything to make it seem like they were subcontractors. And I think it was the name escapes me, but a married couple ended up being criminally prosecuted, and they pleaded guilty to intentionally evading taxes that were owed. Now that's a rare thing. That's the one and only time I've ever heard of it happening, and it was so unusual that it made local news. Google it if you want; it'll be easy to find, and that can kind of show you I suppose the worst thing that could happen is you end up going to jail, and that obviously that business was just toast after that happened, and they had to pay back a whole bunch of money and were criminally prosecuted. So that's the worst that can possibly happen for a very intentional and systemic issue. Usually they're not intentional. You know, maybe the general contractor, you know, didn't follow, you know, was complying with 10 of the elements, but not the 11th, and didn't realize it. You know, those are not scenarios where you'd go to jail, but they're scenarios that could be financially hurtful for you. Well, possibly even beyond criminal prosecution, at least in my experience, the nightmare scenario was this workers' comp claim. You know, especially in a case of a serious injury, which of course is an unfortunate possibility in your line of work. Someone falls off the roof or breaks their leg or something. those major injuries, if they happen to someone being treated as an independent contractor, may or may not be covered by workers' comp, depending on what coverage, if any, the independent subcontractor carried. So I had that happen to someone who, had a very informal relationship with a guy who just showed up on the job site when asked to do like laboring work. And of course, this being, the legal system, they were on the roof and fell off the roof and broke their hip and ended up with, 7 figures of medical bills. And at that point, remembered that they thought they were an employee, with the help of a lawyer who apparently does exactly that sort of thing, and went to the workers' comp department, which said, yeah, you sure seem like an employee, and then went after my client personally and through their business for more than $1 million. And they add on excruciating penalties and things like that. And it just from kind of informally having someone come on the job, and they were paid by the hour for whatever laboring work they did on the job, and treated like a subcontractor, at least in my client's mind. We were able to settle the case, but cost a bunch of money in legal fees and an awful lot of headaches and problems, and they had to change their business practices and otherwise comply with what the workers' comp department wanted. So there are ways to mitigate that risk, to mitigate the risk of a worksite injury or some other sort of workers' comp problem arising among your subcontractors. Of course, the first one is to have very sound classification practices to make super duper duper sure that you're not misclassifying anyone. But that aside, you can force your subcontractors to carry their own workers' comp insurance. That's certainly something you can do. Say, well, this is another one of those recurring expenses that we're going to make you have if you want to work with us. And you can build it into the price you charge us, but you must carry workers' comp insurance for you and anyone who works with you. In which case, if there's an injury, it will be covered nicely by that insurance. Another thing to think about is obtaining something called if any coverage from your own workers' comp insurer. And I'm not a shill for the workers' comp insurance people, but I think it's a good idea and generally quite inexpensive to get that kind of coverage. What it is I don't think insurer that I have any employees, or at least I don't think that these particular subcontractors are my employees. But I want you to give me coverage just in case someone someday classifies or says that they are, and there's an injury of some sort. So it's kind of a coverage that will cover you in case you've misclassified someone who gets injured. Of course, the cost depends on many factors that that your insurance agent can better advise you on than I can. But my general experience with speaking to people in your industry is that the cost is quite low. Maybe in the 3 figures per year, depending on many factors. So it's something worth having a conversation with your insurance agent about. See if it makes sense for you as a general contractor to get that sort of coverage, because it would nicely protect against that kind of nightmare scenario that I described. Okay, so those are the things that can go wrong. Certainly in kind of summary, you have a set of rules of the road that the government has provided in order to guide your practices on classifying people who work with you. If you meet every single one of those elements, plus they're registered, you should be okay. If there's any kind of problem with any one of them, you might get into trouble on one of these issues, and extremely bad things can happen. So it's something worth paying attention to. Excuse me, it's something worth having serious discussions with your subcontractors about. It's something worth having serious discussions with your insurance agents about and your lawyers to make sure that your contracts are in place, that your insurance is in place, that everyone understands the nature of the relationship, and it's written down in a way that that anyone investigating the situation, whether that's a plaintiff's attorney or a judge or a government agency, is going to be satisfied that they've that all the T's are crossed and I's are dotted. Okay, so with that, I will address any questions you may have.
Hey, Brian, it's Jerry here at J3.
Yeah,
So the not billing by the hour for subs, how does that work with, let's be honest, electricians and plumbers pretty much bill by the hour.
Yep.
How does that work in that case?
those are the folks who tend to be, they are exempt from various, from registration and don't have the same sort of restrictions on their ability to do this kind of work by the hour.
Okay. And does
So-
this stuff apply if somebody's a sole proprietor or an LLC? Are the rules different versus working with, somebody who's registered as an S or C corp, for example?
No difference at all.
Okay.
Although it's a good idea, it's certainly a mark in your favor of truly independent status if the subcontractor is a business entity. Now, it's not the end of the analysis. Certainly, subcontractors who set themselves up as business entities can be deemed employees. That happens all the time. But it's less likely they will be, because it's just an indicator that you really have a separate business, that you took the time and effort to create a legal entity.
Got it.
Other questions?
Hi, Brian. This is Amanda Brockhouse.
Yes, hello.
So is it our responsibility as the business owner to do some research to the subcontractor for their social security number or their tax ID number to make sure it's their legit number?
No, it's not. Generally, on that issue, I guess the standard operating procedure that I've seen is to simply make sure in the contract that you sign with them that they're promising that they're complying with that element. If they're kind of secretly not, or something like that, and you had no way of knowing, then no one's going to fault you. If you're otherwise, if the other elements are met, and you say, well, they told me they had a separate, and I looked them up and they told the government that too. I mean, what do you want? So I don't think that would get you into any trouble.
Yeah, because I make them build the W-9, they got the Department of Labor and Industry number, plus they've got, everything else in line. So how am I supposed to know if they swam across the river or not?
Right. You could only know what you know. And if they're defrauding you, I don't think the government would be all over you on that, assuming you're otherwise kind of scrupulous about treating them as a subcontractor. The things you have any control over these. Other questions?
It's pretty straightforward anymore.
Yeah. Yeah, I wish it were simpler. I can tell you that it gets, like with the federal government, if they get involved, there's like 20 factors and it's even more complicated. I wish they would simplify these things, but at least we have an industry-specific set of rules that really does speak to some of the issues or concerns that the government has with your industry and allow everyone to at least try to be on the same page.
Is it, if a sub works fairly exclusively for a single contractor, but maintains his own business and all that, that's still going to be considered an employee then, isn't it?
No, I mean, it doesn't help in a close case that they only work for one company, but as long as they're able to work for anyone else, but simply choose to work for you just because you're better or want to, there's nothing inherently wrong with that, as long as all other elements are met.
Okay.
The problem is very often in that scenario, all the other elements aren't.
Sure.
But you certainly, if it's done kind of scrupulously, you can, and everyone's on the same page as far as this true independence of the two businesses, you can have that sort of, de facto exclusive relationship, as long as the agreement doesn't say thou must only work for me.
Sure. Okay, that makes sense.
You can say, hey, if you want, you can spend half your time working for someone else. It doesn't matter to me as long as you get done what you've agreed to do for me.
Hey, Brian, it's Amanda again. So if that person that does exclusivity with us, is it okay that we put their subcontractor agreement with all the requirements on that subcontract agreement, that you have to have your own tools, you have to have your own supplies, you have to have your own stuff? Would that make it easier, even though they're just working for us, doing our work that we need done as a subcontractor?
Yes, your subcontract agreement very much should. In fact, most of them just say exactly the words that are in that statute. You as a we agree that you are an independent contractor and we're not going to be W-2ing you or treating you as an employee in any other way. And then we go through each one of the elements and say, agree that you're totally gonna, incur the main expenses and, and so forth, and go right down the line. For what it's worth, I can say that, you can have that nice contract, and if you, I can say, then probably you'll all agree with me that it's happened in that industry, that everyone gets a nice contract from a lawyer or the internet or someone and signs it and puts it in a file and continues to operate exactly as they have. So you can have a nice contract. It doesn't automatically mean that you have that the contract will govern and that you really are subcontractor, general contractor, and not employees, but it helps. It certainly helps if done right, and it's one kind of check mark in your favor on the checklist of investigators, that you have a nice contract and that everyone, two adults or separate businesses, have legitimately agreed that they are independent contractors.
So how many contractors actually steal the information right from the one that's given from us from the state of Minnesota, that's like just 6 to 8 pages long, and then write our own little words in it and change out a few other things? Is that still legit if we make changes to what the government suggests?
Well, you certainly can change it. I wouldn't mess with the part about you being independent contractors. Other business terms, all you want, in fact, that's normal and expected that you should have a negotiation over what terms you want. But the parts where it says that you are independent contractors and that you're totally separate businesses, don't mess with those.
Okay.
Other questions?
No, appreciate your time today, Brian. Thank you.
No problem. Yeah, hope this was helpful. I think you all should have my contact information. Otherwise, hjlawfirm.com for more information about us and me. We do a lot of work with contractors on every aspect of this, and would be happy to answer any individual questions or otherwise help you out.
Perfect. Thanks, Brian.
Have a good day, everyone.
Yeah, you too.
Bye.